First up, we've got People versus Ted Rosenkrantz. It's file 25-7082. Counsel, you want to state your appearances, please, beginning with the People?
Melissa Goodrich, Wayne County Prosecutor.
Good morning. May it please this honorable court, Kareem Johnson, on behalf of Ted Rosenkrantz, P number 71988. Your Honor, I am asking the court to excuse the presence of my client. I did receive a phone call from his care worker this morning indicating that he has had his leg amputated and is bedridden. I have instructed her to provide the information to the prosecutor's office in person today. She will be delivering those medical records. And this is a motion hearing. I don't think this is a critical stage that would demand his presence, Your Honor.
Okay, any objection to that, Ms. Goodrich?
No objection, given the reasons stated.
All right, we'll excuse his presence for the reasons you stated, Mr. Johnson. And it is up for a docket call as well, but really the sum and substance is your motions that are going to inform how the case goes forward anyway. So I have had a chance to review. You have a motion to quash counts 2, 3, and 4. Excuse me, as well as a motion for a special jury instruction, but it seems like that is perhaps in the alternative. So maybe we should first.
Before we dive in, just a quick note. This commentary is created for educational purposes, designed to help those who may be confused or curious about courtroom processes. If you don't find it helpful, feel free to skip ahead. But for those who want a deeper understanding, stay tuned. It's about to get intense. What looks like a routine motion hearing is actually shaping up to be a major constitutional showdown. The defense isn't arguing about whether police had probable cause. They're arguing something far more fundamental: whether officers had the legal authority to enter a private home without a warrant. If the judge agrees, multiple felony charges could disappear before this case ever reaches a jury. Keep an eye on the Fourth Amendment issues here, because they're about to become the centerpiece of the entire hearing.
Argue your motion to quash?
Yes, Your Honor.
Okay, and I did not receive a written response from the prosecution. Just want to confirm one was not filed and you're just arguing. Okay.
Yes.
All right, Mr. Johnson, go ahead with your motion.
Yeah, I won't reiterate everything that's in the motion. Obviously, there's two issues the court has to look at. One, legally, did the police have the authority to enter the home of my client to effectuate an arrest? And it is our position that the police did not. They did not have an arrest warrant. They did not have a search warrant. And we do not believe there was exigent circumstances that would allow them to enter the home to make the arrest without a warrant. And so the second issue the court has to look at is whether or not the district court judge abused his discretion and binded it over. And to that, I have the court just look at or read his reasoning. As I was sitting there in court, I obviously thought that the case was going to be dismissed when he recited the applicable case law and even a new case that still I don't think has been cited in his reasoning. But, he ruled against us. And I think that that was an abuse of discretion. I don't believe he specifically stated that there was any legal exigent circumstance that would allow the officers to enter the home to effectuate an arrest at that time. And I think that there was a concession and an admission by all parties that these officers did not have an arrest warrant or a search warrant. So we'd ask that the motion be granted, Your Honor. Does the court have any questions for me?
I do. Your argument that there was no lawful basis for entry into the home to effectuate the arrest would affect counts 3 and 4, the resisting, obstructing charges inside the home. As I reviewed the preliminary examination transcript and the arguments and the ruling, it appeared that count 2, the attempted felonious assault with the hammer or meat tenderizer, is predicated on the defendant brandishing the weapon to the officer while the officer was standing on the porch and making some kind of threat. So can you articulate what's your basis for quashing that count?
Because I believe under those circumstances, my client had a right to stand in his home armed and let the police know you cannot come in here. Uh, I didn't see a Michigan case uh, in which deadly force to prevent unlawful entry by law enforcement was authorized, but I know the case out of Indiana that started all this on a national level. That was a deadly force case in which the defendant shot officers who entered his home without a warrant. So it's my position that the reason why that count should be quashed is because it is not a felonious assault as a matter of law. If I stand in my doorway, even with a weapon, and tell individuals who have no right to enter my home, you cannot enter my home and leave my property.
All right, thank you, Mr. Johnson. Ms. Goodrich, what's the people's response?
Thank you, Your Honor. Count 1 does not appear to be at issue. The strangulation
Correct.
was appropriately bound over, and then count 5 is a misdemeanor. So it's as to count 2, 3, and 4. I believe that the court properly bound those over, and stand by my arguments at prelim that the circumstances where they had just finished interviewing a victim of a strangulation, domestic violence, there is a minor child, the defendant's minor child, outside the home. The defendant is standing at the see-through screen door, brandishing a weapon, telling the agitated and telling the officers, let's party, and being aggressive towards them with a meat hatchet hammer in his hand. That given those circumstances, the officers certainly are going to retreat and leave the scene, and pursued the arrest on the strangulation, which resulted in the RNOs and attempted assault with a dangerous weapon.
All right, well, the defense has moved to quash the information, the bind over of counts 2, 3, and 4. I reviewed the preliminary examination transcript. My review is whether the district court abused its discretion in binding the case over. But an error of law does constitute an abuse of discretion, and issues of law are reviewed de novo. As to the count 2, that Ms. Goodrich, I guess I do have one question. Have I properly understood the factual basis for that charge being the brandishing of the weapon and the threat while the defendant was inside the home and the officer was outside the home on the porch?
Yes.
Okay. The elements of that offense would be, the possession, the use of a weapon to attempt an assault, which is to place the officer in fear of an immediate battery. The threat that was made by the defendant, he's standing in his home and shaking and displaying for the officer an object that certainly could be used as a weapon, a meat tenderizer, referred to as a hammer in the charging documents, and it could certainly be used as a dangerous weapon. He's saying that the record was, we're going to have a problem if you come in here. And one of the officers said, quote, he said if we entered the home, he was going to fight. At that moment in time, the officers are outside the home. There's a door in between them. If Mr. Rose, I don't know that I agree with the defense position that he can use, deadly force at that moment to keep them at bay. He can't point a gun at them through the door. I think that would place the officer in an apprehension of an immediate battery. But I don't need to reach that issue for this charge. It's a hammer of sorts. And there's no indication that through the closed door, the officer was in fear of an immediate battery. It was a conditional threat at most, not an attempted assault at the moment the statement was made. It was saying, if you do X, Y, Z, then I will assault you. That's not an attempted assault. It's a condition that he's stating. If you come in, we're going to have a problem. So I just think the elements have not been established, even on a probable cause standard, that at that moment in time, that conditional statement was not an attempted felonious assault. So I'd grant the motion.
This is a significant victory for the defense. The judge has just ruled that the alleged threat involving the hammer does not satisfy the legal elements of attempted felonious assault because it was conditional rather than immediate. In other words, saying if you come in, we'll have a problem is legally different from making an immediate assaultive act. Notice how the court carefully separates emotional reactions from legal standards. Even conduct that sounds threatening must still fit every required element of the charged offense. Do you agree with the judge's distinction between a future conditional threat and an immediate assault, or should the charge have remained for a jury to decide?
Motion to quash count 2, finding an abuse of discretion in the bind over that charge. Counts 3 and 4 are resisting obstructing charge. The officers did enter the home to effectuate an arrest on the count 1, the assault by strangulation, the domestic violence charge. They certainly had probable cause to make that arrest. And when they entered the home to effectuate the arrest, the defendant did engage physically with them and resist that arrest. The defense position is, well, the elements of resisting obstructing require that the officer be engaged in the lawful performance of their duties. And also at the common law, there is a right to resist an unlawful arrest. It may not be a wise decision in, tactically in moments of time, but at the common law, and Michigan has continued that there is a right to physically resist an unlawful arrest. And here, the officers both testified that when they arrived at the scene, there had been a caller, the stepdaughter, the victim's stepdaughter, the defendant's daughter, had called 911 to report that the defendant had assaulted the victim. When the officers arrived, both the caller and the victim were outside the home. It appeared that initially the defendant was also outside the home, but quickly retreated inside it. So then while the officers are conducting their investigation, the victim and the reporting party are outside the home. The defendant's inside the home and one officer is speaking with him through the door. The officers, after completing their interviews on the scene, developed probable cause to arrest Mr. Rosencrans for the strangulation assault and the domestic violence. And I think the defense concedes that there's at least probable cause to make that arrest. Both officers, however, did testify on cross-examination that they had no reason to believe that there was anybody else inside the home other than the defendant. Both officers testified on cross-examination that they had no indication that the defendant was imminently destroying any evidence. So therefore, there's no exigent circumstances or need to render emergency assistance. So for example, when officers respond to a domestic violence call, oftentimes the complaining witness or the caller or both are inside the home. And that creates an exigency and a need to render assistance where officers are routinely entering homes to investigate a domestic violence. And that's, in most circumstances, going to be entirely proper. And perhaps that made these officers a little, a little complacent about the situation. This was different. When they arrived, there was no danger inside the home. All the parties were outside the home. The only one inside the home was the suspect. And so there's no exigent circumstances. All they have is probable cause, no warrant, no exigent circumstances. That is Peyton v. New York in 1980. The United States Supreme Court said that entry into the home is the chief evil against which the Fourth Amendment protects us all, and that officers may not enter a home to effectuate an arrest, even if it's a felony arrest, even if they have probable cause, unless they have an arrest warrant. And here they did not. So I just don't see how this isn't on all fours with Peyton v. New York. So the entry into the home was since 1980, black letter law, unlawful. And therefore the officers were not engaged in the lawful performance of their duties inside the home. The defendant did have the right to resist that unlawful arrest. So therefore, it's an abuse of discretion and error of law to bound over counts 3 and 4. The motion to quash.
The defense walks away from this hearing with a substantial win. The judge granted the motion to quash counts 2, 3, and 4, finding that the attempted felonious assault charge lacked sufficient evidence under the legal standard presented and that the officer's warrantless entry into the home violated established Fourth Amendment protections. Because the court determined the arrest inside the residence was unlawful under the circumstances described, the related resisting and obstructing charges could not stand. What remains are counts 1 and 5, which the parties will address at a future docket call. This hearing is a powerful reminder that criminal cases are not decided solely by what happened, but also by whether law enforcement actions comply with constitutional requirements. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Is granted as those counts as well. So Mr. Johnson, counts 2, 3, and 4, your motion's granted. You can submit an order to that effect. And I suppose that renders your motion for a special jury instruction moot, does it not?
Yes, Your Honor, it does. We will withdraw that motion.
Okay, so we should probably schedule this for a further docket call so that we can see how the parties wish to proceed on counts 1 and 5. How about March 10th, Mr. Johnson?
Yeah, on March 10th, I'm scheduled to be in a attempted murder. Well, it's now a discharge of firearm at a building trial in Washtenaw County.
Okay, what about March 17th?
Scheduled to be in a homicide trial in Ingham County. That's going to be 2 weeks.
All right, well.
Well, Your Honor, Ingham County does not, I'm sorry, I didn't mean to cut the court off.
No, go ahead.
Ingham County does not have trials on Wednesday, so I don't know if this court is available on Wednesday.
All right, well. Well, I've got some scheduling. We don't have a whole lot of criminal motion days in February, March. And so I prefer to do them on Tuesdays, but I think in these circumstances with your trials, Ms. Goodrich, would you object if we put it on? Would Wednesday, March 18th work then? Mr. Jackson?
Yes, Sean, it would.
Ms. Goodrich, if we put that at the end of recovery court that day, say at 10 a.m.?
No objection.
So we could do this on a special day then, March 18th at 10 a.m. And Zoom appearances would be authorized. Bonds continued. And you'll submit an order as to your motions, Mr. Johnson?
Yes, Sean, I will.
Okay, anything further from the people?
Does the court require an amended information then, or we just leave the count?
I don't think so.
Okay.
Because we'll just enter it as dismissed by the court. So we can proceed on the information. And then if it goes to a trial, we'll just fib to the jurors about the count numbers.
Okay.
Okay. All right, anything further from the defense?
No, Your Honor, thank you.
Okay, thank you both. Have a good day. All right, and we'll be in recess until 10 a.m. We've got our 9:30.